My name is Will Francis, and I would like to thank the committee for the opportunity to testify. I am the Government Relations Director for the National Association of Social Workers Texas chapter, and I represent around 6,000 NASW Texas members around the state. We want to thank the authors for drafting a comprehensive bill that recognizes the need for a variety of reforms in multiple areas of child welfare. We recognize how daunting the task is and would like to highlight some of the areas of SB 11 that we think do an excellent job of bringing solutions to areas of concern. Studying the recidivism rates, developing a foster care capacity plan, and establishing both geographic risk mapping, procedures, and an ethical framework for their use are much-needed data collection and evaluation guidelines that should ensure the department is making sound decisions as they work with families and develop strategic plans. The focus on evaluating prevention programs and assessing vendors will help contain costs and identify successful areas of service delivery. The attention to the medical needs of children is a strong component of the bill. Separation of regulatory functions to HHS and investigative duties to CPS under RCCL is absolutely necessary. The Office of Workforce Development and Analysis is a stellar piece of the bill as well. We would, however, like to voice our concerns regarding the issue of moving case management services currently handled by the department into the community, and caution the legislature to ensure that they carefully consider and explicitly define the role of the department going forward. The Quality Assurance Division and CPS staff should have real-time access to children, databases, CPS caseworkers, and parties in the legal system. Paperwork, plans, contacts, and all of the reports related to children must be maintained in a central repository accessible by the contractors and the state, or else children move between placements or youth re-entering care or seeking their records at age 18 may have alarming gaps in their histories. The bill states the department must wait 18 months before the review of a contractor. While this is a necessary step aimed at evaluating the performance measures, it does not take into account the level of accountability that must be maintained by the state on a daily basis. The provision for ongoing community collaborations is excellent and could be expanded. The legislation should explore appointing an ombudsman solely for the redesign region, similar to the position created last session. This person could help the department maintain a direct connection to youth in care who do not have their CPS workers any longer, and they could offer outreach and education aimed at youth in addition to their role handling complaints. There must be greater penalties for performance measures that result in poor outcomes for children over benefits for meeting benchmarks. It is easy to envision a scenario where a contractor makes a decision that achieves what looks to be an external success but ultimately conflicts with the best interests of a child. As an example, if a parent with substance abuse issues is working on their sobriety, suffers a relapse in 9 months, and immediately contacts their caseworker, gets in touch with their sponsor, and takes positive steps towards recovery, under the current CPS framework, asking for a 6-month extension to prolong the case past the year mark to 18 months would incur no penalty. But in a system where a contractor is given performance measures related to the number of children who have achieved permanency by 12 months, it could look better if the parent's rights were terminated and the child were moved towards adoption. Additionally, this might cost the contractor less, and their relationship with the foster family that they recruited, trained, and supported might take precedent over parents struggling to retain their kids. We strongly recommend that SB 11 contain the provision that an outside entity, such as an institution of higher learning, evaluate the current foster care redesign catchment area. The bill instructs the department to do so, and the current contractor has done a great job of providing their perspective on the process, but without an independent evaluation, we are seeing a one-sided picture. A review team with no connection to DFPS as a contractor can highlight the areas that are successful, the parts that need modification, the ideas that should be carried into new areas, and the feasibility for future success based on a total exploration of the program from its beginnings up to now. With this independent evaluation, without this independent evaluation, we truly don't know what redesign looks like from top to bottom. Overall, we think it's a strong bill and just recommend additions to certain areas.
Thank you.
Thank you for the opportunity to testify.
Yes, Senator Short.
I don't want anyone to think that this in any way is going to increase numbers of removals from families in the sense of instead of reunification going toward adoption. That's up to the judge and the courts in all cases, correct?
It's up to the judge to make the determination, but when it comes to the actual contracting of services and providing, say, when it comes to substance abuse services, when it comes to counseling, when it comes to others, if that's a performance benchmark that they're rated upon, we have concerns that unless the department has the real-time evaluation of what services are being offered and how, and if they don't have access to the decision-making processes by the SSCs, then no matter what the judge says, contracted dollars and contracted services may be withheld, and decisions may be made to recommendations to the court on outcomes for kids that are ultimately based on what is being spent and not necessarily what's in the best interest of the child.
Any other questions, Senator Watson?
I just want to make sure what you're saying is that the party that's dealing with the child will be making representations to the court and may also be, well, not may, will be involved, well, in the report, telling the court what's going on, and in that way, the court will make the ultimate decision, but the court will be influenced by what the report is.
Ultimately, and I think Senator Shorter has made a very good point. Currently, we've had a caseworker in that position. Now we would have a contracted caseworker in that position. And we just want to assure that the contracted caseworker in that position is not making recommendations which ultimately affect more of the contract in the best interest of the child.
Yeah, it's almost like the assumption that the caseworker, that is the employee of the nonprofit or governmental entity operating as SECC, is operating in a nefarious manner. And I don't really like that.
I apologize if you take it, but I'm saying that ultimately, right now, if a caseworker makes a decision, it
There
comes
are
out
lots of
benchmarks.
there's lots of decisions made, unfortunately, by caseworkers about closing cases right now that are detrimental to the care of that child.
There are no
And
closed
if you-
cases from the conservatorship standpoint, which is who stands there in court. Cases are closed on the investigative side. As a former conservatorship worker for CPS, I never was pushed towards closing a case. We had 12 months which to solve a case and up to 18 months with an extension. So I think that saying that a caseworker is closing a case once a child has already been removed from their parents is actually is not quite what happens within the system.
I guess the premise that somehow a caseworker that is affiliated with a not-for-profit or governmental entity that is community-based, that has a vested interest, is somehow going to provide inferior case management services, and then tell that to a judge, and the judge acting in a manner that is detrimental to that child is harder for me to
Let me say it
accept.
slightly differently.
Senator Watson.
Yeah, let me say it slightly differently, just because I think it's important for us to think through the context of this. Not nefarious, I'm gonna take that, I'm gonna set that word aside. But let us do say, right now, the CPS caseworker has no profit incentive.
No, they have plenty of pressure at times.
Well, they may have pressure, but let me start off with this. Two wrongs don't make a right. And what we're hearing is a concern that the CPS caseworker, who is a public servant, they may be under pressure, maybe pressure we've created for them, frankly, but they may be under pressure, but that public servant has no profit motive to close cases. And by profit, I get it, they can be a not-for-profit, but it's a money thing. And so what the concern that we're hearing over and over again is not that they'd be, I don't want to use the word nefarious, but they have a motivation, a motivation different than the public servant to get the cases closed, because that's how we're going to grade their papers. Now, how many of that occurs, who knows? And you're right, there are pressures that we put on them otherwise. Two wrongs don't make a right, but it is something we need to think through, because we are hearing that multiple times.
From an oversight standpoint. Now, I've tried to address it, Senator, through, again, the quality assurance division.
I'm just saying.
How we contract, case reads, and a number of different avenues.
I'm not suggesting you haven't heard it, but I'm just saying that as we finesse this and work on it, we can't ignore that.
No, I agree. I'm open to all suggestions about how to strengthen the bill or make it one that the majority of the legislature thinks is the right path for the state of Texas.
Or at least 19.
Or at least 19, yes, sir. Thank you for your input. I do appreciate it.
And I do
very much.
apologize if it seems like I was denigrating the CPA caseworkers. I've worked with CPA
Yeah, I mean,
caseworkers. I know what
there's
they can
lots
do.
of great individuals out there that want to do at the community level. Yeah, the state can do good things, and our caseworkers at DFPS do good and great things. But I think the solution to foster care is a greater engagement of the community and a greater engagement of the faith-based community, and not-for-profits that have a vested interest in child welfare. And the more we can empower those individuals, and case management is one of those avenues to do what's in the best interest of that child, I think is something we should explore and allow, because certainly what we have right now isn't working great. And I think we should allow for some trial. It seems to have worked well in 3B, and there's a push for it, I think, on a statewide basis, and interest in it, and I think we should allow that to be explored.
Okay.
We'll continue to talk about it, I'm sure.
I thank you.
Thank you.